Welcome, everyone. Those familiar with the Brouwer Lecture will know that it was created to acknowledge Charlie Brouwer's leadership in the field of international dispute resolution and in the society, of which he's a prominent former president, a generous benefactor, and a beloved member. But more on Charlie in a few moments. The Brouwer Lecture has been delivered by a succession of leading lights in the field, including Johnny Veeder, who delivered the first, and whom we lost this year, Sundaresh Menon, Michael Reisman, Gabrielle Kaufman-Kohler, David Karen, Meg Kinnear, and Judge Peter Tomka. Today, we are very lucky to have with us another leading light, Sir Daniel Bethlehem, QC. Daniel practices public international law at 20 Essex Chambers in London. He previously served as the principal legal advisor of the UK Foreign and Commonwealth Office and was director of the Lauterbach Center for International Law at Cambridge University. He was knighted in the Queen's Birthday Honors List in June 2010. As counsel, Daniel has appeared in a number of the major international fora, including the ICJ, ITLOS, UNCLOS tribunals and conciliation commissions, WTO panels, the Iran-US Claims Tribunal, and the European Court of Human Rights. Daniel also has engaged extensively with the United Nations and its specialized agencies. And as arbitrator, Daniel's been appointed in both investor state and non-investment cases with notable experience both PCA and ICSID-hosted arbitrations. I've had the great privilege of getting to know Daniel over the years, and Daniel epitomizes to me the preeminent international lawyer of today, engaging the world of international law brilliantly as a government lawyer, a counsel advocate, an expert, a professor, and an arbitrator. His writings are equally diverse, covering the use of force, the law of armed conflict, the law of state responsibility, immunities, and as you'll hear more. We're delighted to have Daniel as this year's Brouwer Lecturer. The title of his lecture is The Greening of International Dispute Settlement, ? Stepping back a little. We'll be a bit pressed for time, so as Daniel speaks, those that have questions, please go ahead and submit them using the Q&A function as they come to you, and don't wait until the end. But with that, and no further ado, Daniel, over to you.
Catherine, thank you very much indeed. I was going to say thank you for reading out the introduction that I wrote, but we are. I mean, everyone will appreciate that I'm looking at you on the screen, you're looking at me, but there are, I hope, people out there in the ether to whom we are speaking. So it's a rather surreal experience, but many in the society are I think, enjoying it. Thanks for the introduction, and welcome to a very hot and humid London in the late afternoon. It's a great pleasure to be here, most importantly to honor Charles Brouwer, and I hope and presume that Charlie is out there, even if he's not immediately visible to me. I'll have a little bit more to say about him in just a moment. It's also an honor to be giving the Brouwer Lecture at this first virtual annual meeting of the Society. I understand that there is record attendance. I think something like over 2,000 people have signed up, which is quite extraordinary. And it really is a testimony to the strength of the Society that it has attracted such participation. And Catherine, this is your first annual meeting as president. I think you were denied the traditional handover in April, but I'm delighted to be speaking here under your gavel, and I wish you much success in your tenure to come. You've recalled my predecessors at this rostrum. Let me do so as well. I've had the benefit and advantage of reading all of the last numbers of lectures, starting with Johnny Veeder of blessed memory. And I'm honored to be joining their ranks. An additional reason for the particular pleasure that I take to being here today is that from my vantage point, we are at a turning point of our shared calling in pursuit of law, a just and effective law to govern our changing international society. You referenced Justice Menon in his second lecture in the series, and he in turn referenced Thomas Friedman's The World is Flat in his remarks. The theme of that book, the globalization and the individualization of the world through its connectivity, is an important one for our calling. I addressed this in an article some years ago entitled The End of Geography, And there are some themes of that article that I would like to tease out a little bit further today. The point for now is that, at least as I see it, we are indeed at a turning point. It's not a corner, it's not a juddering change of direction. It's more like the slow arc of a supertanker changing course to adjust to the weather. Although without the benefit of a port of destination and the instruments of navigation that would otherwise be available to the captain to set a considered course. Our calling is to stumble into the future without a clear vision, but hopefully with a benign and honest intent. And I hope that this sense of a turning point, which informs my remarks today, will become clearer as I go on. Now, the Brouwer Lecture cannot start without some words about Charlie. I have had the pleasure of knowing him for approaching 3 decades. I still bear the scars of the arm twisted up behind my back as he approached me to become patron of the society. I must say I didn't resist too much, but those are my early recollections. Charlie was then the most effective steward of the society, ushering in, as I recall, a period of well-funded ambition to take the society into a new era. And we are all the happy beneficiaries of his efforts, and even more so of his remarkable generosity to the society. Charlie, the lawyer, the judge, the arbitrator, is well known to us all. I will not dwell on these aspects, and note only that I have had and I have the honor of appearing in front of him in his capacity as arbitrator and judge. The strength of his spine, the sharpness of his intellect, the balance of his compass are impeccable. More important still is his generosity of spirit and personal kindness. Charlie, I'm looking at you now. It's an honor to be speaking here today in this lecture series that carries your name. So, to my topic, the greening of international dispute settlement, question mark. And the question mark is very important. Stepping back a little. It's not an obvious title, save perhaps for a post-war American generation who came of age in the 1960s, who will recall the publication in October 1970 by a Yale law professor, Charles A. Reich, of a book that was to become an immediate bestseller, The Greening of America. Under the bold title of the book, on the front cover, you see it over my shoulder, were written the following words: "There is a revolution coming. It will not be like revolutions of the past. It will originate with the individual and with culture, and it will change the political structure only as its final act." These were bold words, and a book that captured and was captured by popular culture at the time. Now, I was a boy of 10 at the time of its publication, growing up in the southernmost tip of Africa, in a society that was at the time the very antithesis of freedom and equality. I was too young to read the book then, it's 430 dense pages, but the idea of the book, brought home by my father from a trip to the United States, along with Crosby, Stills, Nash & Young's Deja Vu, which had just come out, has stuck with me ever since. In contrast to the book, I am not predicting or proposing revolution, and the greening epithet is not an environmental intonation. What I have taken from the book, however, and from its resonating title, is the idea that there are turning point moments, that there are moments for reviewing and refreshing, that times change, and that rethinking is not repudiation. It is rather a recognition that historically rooted institutions may not sufficiently clothe the corners of the society that we have become. It is the possibility of the greening of international dispute settlement that I would like to explore today. In a speech to the American Bar Association on the 24th of January, 1982, the then sitting Chief Justice of the United States, Warren Burger, quoted both Abraham Lincoln and Judge Learned Hand. Lincoln, he recalled, had said, and I quote, "Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time, close quote. Learned Hand, Justice Berger recalled, had commented, and I quote, "I must say that as a litigant, I should dread a lawsuit beyond almost anything else short of sickness and of death," close quote. Now, these recollections were intended to frame Justice Berger's own observations, captured by the title of his speech, "Isn't There a Better Way?" Opening his remarks, Justice Berger said as follows, and I quote, "The obligation of our profession is, or has long been thought to be, to serve as healers of human conflict. To fulfill our traditional obligation means that we should provide mechanisms that can produce an acceptable result in the shortest possible time, with the least possible expense and with a minimum of stress to the participants. That is what justice is all about." And Justice Berger continued, "The law is a tool, not an end in itself. Like any tool, particular judicial mechanisms, procedures, or rules can become obsolete. Just as the carpenter's handsaw was replaced by the power saw and his hammer was replaced by the stapler, we should be alert to the need for better tools to serve our purposes." That was the Chief Justice of the United States. It is this inquiry, elevated to international dispute settlement, that I would like to explore. International dispute settlement, or IDS, has been an extraordinary engine for the development of international law over the past nearly 230 years, and more particularly over the past 120 years or so. I will consider why and how this has been the case as we go along, but for the moment, I simply assert the proposition. My nearly 230 years is intended to recall the Jay Treaty of 19 November 1794 between Britain and the United States, which in various of its articles provided for binding arbitration. It is the Jay Treaty that is frequently considered to be the font of IDS today. Addressing the arbitrations that subsequently took place pursuant to the Jay Treaty, Georg Schwarzenberger, in a 1978 article, commented that the quality of the awards rendered is impressive, noting further that it was the work of the Commission under Article 7 of the treaty which, quote, "produced the Commission's most remarkable contributions to substantive international law," close quote. It was, though, not only the Commission's contribution to substantive international law that was notable, but also their contribution and that of the Jay Treaty to what have since become core procedural tenets of international adjudication. My reference to the past 120 years in particular is intended to recall the Hague Peace Conferences of 1899 and 1907, at which were adopted the successive Hague Conventions No. 1 on the Pacific settlement of international disputes, one element of which was the establishment of the Permanent Court of Arbitration, the PCA. I will come back to these conventions a little later. For the moment, I note simply that the establishment of the PCA and its competence in respect of arbitration saw a steady stream of interstate arbitral disputes referred for settlement in the period prior to the establishment of the Permanent Court of International Justice in the early 1920s. The PCIJ was, of course, anticipated in the Covenant of the League of Nations. It largely picked up the baton of international dispute settlement in the period 1923 to 1940. Now, it will not have escaped your attention that rooting the narrative in the Jay Treaty Commissions, in the Hague Conventions of 1899 and 1907, in the PCIJ and in the PCIJ, the PCA and the PCIJ, leads inescapably to the appreciation that the framework of international dispute settlement with which we live today is largely 19th century and early 20th century in origin and structure. There have, of course, been more recent developments, ICSID, UNCLOS dispute settlement, WTO dispute settlement, and more. But key pillars of the contemporary international dispute settlement architecture remain grafted on to 19th and early 20th century roots. The 1899 and 1907 conventions are still a cornerstone of the contemporary IDS system. The PCA, modernized through the reach of its arbitration, conciliation, and other rules, has since 1996 attracted a resurgence of interstate cases. The International Court of Justice, while born with and of the United Nations, is heavily anchored in its statute and rules in its PCIJ predecessor. And it's not just the institutional roots of IDS that are anchored in the 19th and early 20th centuries. So also are key features of the adjudicatory system. I will develop this idea more fully shortly, but for the moment, let me simply note the heavily state-centric nature of IDS today and its opt-in character of consensual jurisdiction. Some steps have been taken to move away from these aspects, with investor-state dispute settlement, through the compulsory settlement commitments of UNCLOS and of the WTO. But the IDS system today, for all of its developments, would be recognizable and familiar to Elihu Root, to Charles Evan Hughes, and to James Brown Scott, who led the society from 1906 to 1939. Let me pause here for just a moment to address what I mean and what I exclude when I refer to international dispute settlement. I take IDS to mean the settlement of disputes arising from competing claims of law and legal obligation and the conduct required thereby under public international law, whether treaties, custom, or some other source of law. I am not including negotiations or diplomatic mediation. That would broaden my horizon too far. The definition that I take as my starting point is nonetheless at once both broad and narrow. It excludes the resolution of purely contractual claims between non-state litigants. It excludes, therefore, very largely many of the claims that are addressed routinely under the aegis of the International Chamber of Commerce and similar institutions. But what the definition does include is disputes arising from claims rooted in international law before domestic courts, not just those that are heard by international courts and tribunals. This is very deliberate, as I see it, informed both by my private practice over the past 30 years and by my time as legal advisor of the Foreign and Commonwealth Office. Many disputes which turn on contested claims of obligation under public international law arise before domestic courts and tribunals, or have a hybrid quality in which the same dispute is addressed in both domestic and international fora. Let me return to my narrative. I framed my reference to the Jay Treaty, the Hague Conventions, the PCA, and the PCIJ by suggesting that IDS has been an extraordinary engine for the development of international law over the past nearly 230 years. Let me develop this further, both with some numbers and with some reflections on the legal theory informing and driving this development. Starting with some numbers, the institutional sources of international law adjudicatory decision-making have broadened significantly over the past 75 years. The pre-war institutions and ad hoc fora have been supplemented, as well as by the ICJ, by the panel decisions of the GATT of the WTO and by the WTO appellate body. The conclusion of the ICSID Convention in 1965 has led to many hundreds of investor-state disputes being addressed under the centre's auspices. These cases being supplemented by still more investor-state disputes being addressed under the auspices of other settlement mechanisms, notably the PCA. The Iran-US Claims Tribunal has, in its approaching 40 years of operation, addressed almost 4,000 claims arising out of the events of the Iranian Revolution of 1979 and the period immediately following. Adopting a different approach to the settlement of mass claims, the UN Compensation Commission established to address claims of loss, damage, and injury arising out of the Iraqi invasion of Kuwait in August 1990, received 2.7 million claims. By the time it concluded its work in 2005, 19 panels of commissioners had awarded a total of $52.4 billion in compensation to approximately 1.5 million claimants. Then there are the various regional human rights courts and commissions, the most active and long-serving being the European Court of Human Rights. In its most recent report, it states that since it was established, the court has decided on the examination of around 882,000 applications through a judgment or decision or by being struck out of the list. Over 20,000 of these decisions have taken the form of a final judgment on the merits. The growing acquis of other regional human rights adjudicative bodies adds to these numbers. Not to be overlooked are also the judgments and decisions of the international and hybrid international criminal courts and tribunals, of which there have been many hundreds, each developing the body of international criminal law and informing the development of international humanitarian law. For a more complete picture, we would have to add to these numbers the claims that have been adjudicated before other fora and those more ad hoc in character. Also excluded from this review are countless claims rooted in international law that will have been addressed by municipal courts. Looking more closely at some of the institutions and mechanisms, we see that the PCA has decided, or currently has pending on its docket, 282 cases. Of these, 44 are interstate disputes, 3 of which are pending. These cases have been seminal in interpreting, applying, clarifying, and developing the law. The PCIJ addressed some 57 separate cases, both contentious and advisory. Its jurisprudence is regularly cited to this day. To these, we can add 160 cases decided by the ICJ, 133 of which were contentious cases, 27 of which were advisory. This body of jurisprudence is the day-to-day acquis of international law, addressing everything from the legal personality of international organizations to responsibility for genocide. ITLOS, in its 23 years, has addressed 29 interstate cases, with its judgments and decisions interpreting and applying and developing important aspects of UNCLOS. The ICSID and WTO case statistics are remarkable. In the 48 years since its first case, ICSID has concluded 519 cases, with a further 266 pending, a total of 785 cases in all. The numbers are similar for the WTO, which through its ad hoc panels and appellate body has been seized of 595 disputes, giving rise to 350 rulings. Between them, these ICSID and WTO decisions have put flesh on the bones of international investment and trade law. Now, these numbers are, of course, pretty raw and one-dimensional, and you should not take me as implying that all these decisions are jurisprudentially weighty or sound. I am being much more prosaic, suggesting only that the many tens of thousands of judgments, awards, decisions, and orders rendered over the years have been the lifeblood of the development of international law. The adjudicatory engine of the development of international law does not, however, stem from the numbers. The numbers are the fuel that generate the principles. They are the how. They are not, however, the why. They are not the legal theory informing and driving this development of the law. For that, we have to look elsewhere. And the elsewhere takes us back to some seminal works on international law in the 1920s and 30s, which, often now hidden from view by the passage of time, were instrumental in crafting a philosophy of international adjudication that has powered IDS development of the law to this day. Although he was not alone in this endeavor, a luminary in the crafting of this philosophy was Herschel Lauterpacht. There are 4 propositions that I would single out from his writings, propositions that with the passage of time have come to be regarded as principles. The first is the unity of international law and municipal law. This was a purpose-driven conception of law, born of a sense of the unity of the ultimate focus of all law and the need to constrain the unbridled exercise of sovereign power. The second proposition is that of the supremacy of international law. Supremacy is the cornerstone of many unifying theories of law. For Lauterpacht, international law, the touchstone of principle establishing standards with which states were required to comply, was also an important safeguard against the abuse of human rights. It is equally important for purposes of addressing issues of minimum standards more generally. The third proposition is that of the completeness of the rule of law and the principle of non-liquet. A judge cannot decline to decide a case on the ground that there is no law. Lauterpacht addressed the issue in his seminal work, The Function of Law in the International Community, published in 1933. Let me quote all too briefly from what he said, and I quote, "There may be gaps in a statute or in the statutory law as a whole. There may be gaps in the various manifestations of customary law. There are no gaps in the legal system taken as a whole. Under the normal rule of law, it is inconceivable that a court could pronounce a non-liquet because of the absence of law." Close quote. This is an immensely powerful injunction in the hands of a judge or arbitrator. The fourth proposition is that it is the responsibility of international tribunals to develop the law. In his equally compelling book, The Development of International Law by the Permanent Court of International Justice, also published in 1933 and later refreshed in its second edition in 1957, Lauterpacht addressed the point as follows, and I quote, "The development of international law by international tribunals is in the long run one of the important conditions of their continued successful functioning and of their jurisdiction." He continued, "While the codification of international law must continue to be regarded as a rational and practical object of the collective endeavor of governments, the achievement of part of that objective by other means, and in particular through the activity of the International Court itself, acquires special significance." Close quote. Coinciding with the major institutional developments in international dispute settlement, which put arbitration and judicial settlement center stage, these four principles articulated and developed by Lauterpacht, the unity of law, the supremacy of international law, the principle of non-liquet, and the judicial responsibility to develop the law. These four principles form the bedrock of the adjudicatory development of international law that we have witnessed over the past 120 years. It is by operation of these principles that international law has come to occupy such an important place in the consciousness of the rule of law globally. Armed with an appreciation that their adjudicatory responsibility requires the development of the law, not just the settlement of the dispute of which they are seized, driven by an injunction of non-liquet, resting on an appreciation that municipal law and international law are one, and that international law is supreme. The international judge and arbitrator has been able to craft and develop a body of law through interpretation, through the filling in of gaps, through the articulation of fundamental principles, and even of new rules. This process has made international law what it is today. And to this, I would add a further thought, going to the flexibility that the international judge and arbitrator has had and has in respect of the sources of international law. With only few limitations, the rules of treaty interpretation allow very wide scope for the interpretation of texts. This is complemented by the almost endlessly discoverable and malleable content of customary international law. And drawing on Lauterpacht again, this time in his path-breaking Private Law Sources and Analogies of International Law, published in 1927, the same flexibility is available with regard to the concept of general principles of law recognized by civilized nations, expressed most clearly in Article 38(1)(c) of the Statute of the PCIJ, now the ICJ. In Lauterbach's conception, this contemplates reference to principles of municipal law and other private law sources and analogies for purposes of international adjudication. Viewed in this light, this edifice of many tens of thousands of judicial and arbitral decisions, each articulating, refining, and advancing the principles of international law on which they are based, has been a common law endeavor on a global scale. And it has been an endeavor that has taken place within a framework of only rudimentary hierarchical principles and in the absence of an efficient legislative mechanism capable of acting as a counterweight to judicial activism. Seen in these terms, the proposition expressed in Article 38(1)(d) of the Statute of the PCIJ, now the ICJ, of judicial decisions as, quote, subsidiary means for the determination of rules of law, close quote, seems very far from the true reality of things. Now, I pause here for an aside. I appreciate, especially with many of you, Catherine, you and others, sitting only a stone's throw away from the seat of the Federalist Society, that the picture that I have painted about the responsibility, role, and record of the international judge and arbitrator will cause a shudder to some. Unbridled judicial activism, the worst nightmare. This, though, I believe, is very far from the reality. International adjudicatory decision-making has very largely been measured, considered, and sound. The requirement to give reasons, the transparency, stability, and consistency of the law, its small c conservatism, the need for the Judicial College to remain in step with the society in which it operates. These all push in the direction of considered and calibrated judgments and awards, and only very seldom of juridical revolution. More important, at least in my perspective, is that the development of international law through the adjudicatory process has by and large served the United States and its long-term strategic interests well, whatever the outcome of individual decisions. And the US typically does law very well. It is part of your constitutional culture, whether on the conservative or the liberal end of the spectrum. So returning to my narrative, I must stress that it is no part of my remarks to take issue with the legal theory that has informed the developments about which I have spoken. Through Lauterbach's 4 principles and through the adjudicatory decision-making of courts and tribunals, we have an international legal system. Through this endeavor, we have moved beyond a Hobbesian state of nature. It is true, of course, that challenges remain, but international society today rests on a firm edifice of law. So where does all this lead? Why the question of the greening of international dispute settlement? Where does Justice Berger's inquiry of a better way take us? IDS, in its various forms, is facing considerable challenges at present. The WTO appellate body has been shuttered in consequence of US objections to what are claimed to be judicial overreach. Investor-state dispute settlement is similarly challenged for its ad hoc character, for reasons of procedural and other objections, and more. Less than 40% of the UN membership has accepted the compulsory jurisdiction of the ICJ by depositing declarations under Article 36(2) of the court statute. Hardly a case goes by in which jurisdiction is not challenged. There is a growing trend of domestic courts questioning international human rights judgments rather than acting as enforcers of international law. And many are concerned with some justification with what is often described as lawfare, that there is a sense in some quarters that international dispute settlement has become a second front, not a genuine attempt to resolve disputes, but simply another forum in which to assail an adversary. These are not hallmarks of a healthy system, at ease with the community, that it is supposed to serve. Something has gone wrong, and it feels like more than just another cyclical trough. We should take it seriously. There is also a wider perspective. For all the developments in IDS, it has not kept up with dispute settlement innovation in municipal legal systems. And it has notable shortcomings beyond the headline critiques of the moment. Adjudication is quintessentially backward-looking, addressing the rights and wrongs of what has happened, rather than focusing on rebuilding the relationship for the future. While individual cases may be concluded by a judgment or award, it is less often that the dispute between the parties is brought to an end. Adjudicatory jurisdiction is limited: ratione voluntatis, ratione persolae, ratione materiae, ratione temporis. It is constrained by the petitum of the case. In the case of the ICJ, ITLOS, and the WTO, access is restricted to states. There is no systemic integration of dispute settlement mechanisms. This has led to forum shopping, to fragmentation, and at times to an inconsistency of principles and outcomes. There are real systemic shortcomings that flow from ad hoc decision-making by tribunals that become functus the moment they render their award. There is no unifying theory encapsulating the roles and responsibilities, both of international courts and tribunals and of their national counterparts. More important, perhaps, is that although the availability of alternative mechanisms of dispute settlement features in various instruments, including in Article 33 of the UN Charter, resort to conciliation and a more systematic use of other methods is rare. Of the 785 ICSID cases, only 12 are conciliation cases. The WTO dispute settlement understanding provides for consultations, good offices, conciliation, and mediation, and some disputes are resolved in this way. But the majority are funneled through the adjudicatory process. UNCLOS Annex 5 conciliation has only been used once in the case of the maritime delimitation dispute between Timor-Leste and Australia. For those of you who have not read the report of that conciliation commission, I commend it to you. As someone who saw that process firsthand, I can attest to its effectiveness and its rigor, and the likely enduringly positive outcome, more so than any adjudicatory decision could possibly have achieved. There are now 2 conciliation commission proceedings pending under the International Convention for the elimination of all forms of racial discrimination. It will be interesting to see how they play out. This, though, is almost the sum total of the universe of international conciliation, a teeny fraction of the cases that go to arbitration or judicial settlement. We are therefore, and this is where I began, we are therefore still in the harness of the 19th and early 20th century IDS modalities. IDS has not become more sophisticated with the times. Rules of procedure have been amended, codes of conduct have been produced, but this is all tinkering. There has not been any serious attempt to rethink, to refresh the system of international dispute settlement, beyond adding a patchwork of different forms of adjudicatory mechanisms to address particular circumstances. The last attempt at a new approach, notable but self-contained, was 40 years ago in Part 15 of UNCLOS, with its range of dispute settlement mechanisms. This is laudable, but the Timor-Leste Australia conciliation is so far an outlier. There is a great deal of thoughtful scholarship pressing the boundaries in this area. As I was preparing my remarks for this lecture, I came across many thought-provoking pieces by members of the society, and I commend them all. I am only scratching the surface here. My point is simple. IDS has been the engine of the development of international law for the past 120 years. It has been cosseted and informed by a systemic and strategic conception of the law. It has brought us to where we now find ourselves. But it is also now facing challenges. And while some of these are ill-informed or lack bona fide intent, they cannot all be easily dismissed. More importantly, quite apart from the challenges, there is a question of whether we can do better, whether IDS today is sufficiently sophisticated, sufficiently attuned to the changing nature of international society. My answer to this question is that it is not. IDS has not kept pace with the developments in dispute settlement in municipal settings. While this may be for understandable reasons, the shortcomings are evident. IDS has not kept pace with the changing character of international society. We can do better. Now, this is not a call to sweep away what we have had until now, much less a repudiation of what has gone before. It is simply a call for some fresh thinking to see if there's something to be done today, as there was a century ago, to conceive of a system of international dispute settlement that is more nimble and more in tune with the society it is designed to serve. So how do we do this? And where should we start? It needs no saying, but just in case, I'll say it anyway. We are not in a legislative moment. This is not a moment for grand conferences, for fast-track negotiating authority, for expectations of widespread multilateral buy-in to some new instrument. Politicians are distracted elsewhere, and we are far, very far, from the spirit of The Hague, Versailles, Bretton Woods, and San Francisco. So this is not the route, nor I think can it be a matter for itinerant discussions in a forum such as the Sixth Committee, the Legal Committee of the UN General Assembly. That may have a part to play, but something more is required. There is, I believe, an avenue of endeavor for the invisible hand of our College of Law to examine with renewed interest and focus certain propositions and principles that inform the system of international dispute settlement. The issue of the supremacy of international law and the relationship between national and international law and adjudication is ripe for review, and there have already been many interesting scholarly contributions to this discussion. I have added my few pennies worth in a 2016 published lecture entitled The Supremacy of International Law? I will return to the issue of who and how in just a moment. Let me say something first about elements of an agenda, a theory of change that I think would merit discussion. The leitmotif of the late 19th and early to mid 20th century dispute settlement was the preservation of peace and the avoidance of recourse to force. We see this expressed in Article 1 of the Hague Conventions. It was the cornerstone of the Covenant of the League of Nations. It is the centerpiece of the UN Charter. We do not, however, I believe, have a more all-embracing sense of the purpose of international dispute settlement. If we are to move to a more variegated dispute settlement approach, it would assist if we could better articulate a sense of purpose that is properly in tune with a wider ambition. Beyond this, amongst the issues that might be placed on the agenda, I would put the following. First, we need a more sophisticated and contemporary sense of the interaction between international law and municipal law, and of what the relationship ought to be between dispute settlement at a municipal and international level. Where is competence properly rooted? How do the courts in one sphere engage with those in another? The unity and supremacy of international law would benefit from a little more contemporary prodding. General principles of supremacy, subsidiarity, and margin of appreciation only take us so far. Second, I would be inclined to look again at the principle of non-liquet, not to question its place in the firmament to this point. The issue is rather, given how far we have come since Lauterbach's function of law, whether we need to maintain a systemic antipathy towards gaps in what Lauterbach termed positive law. There are such gaps. The question is, who should fill them, and how should the parties proceed in the face of such gaps? The Lotus principle, that everything is permitted unless it is prescribed, need not be the controlling hand on the tiller. Silence in the law may speak in many different ways. Ours is not an Aristotelian discipline. A vacuum, a gap, is not something to be abhorred and plugged whenever there is a contention. There is another reason for looking at non-liquet. It is that while findings of law may be central to the adjudicatory determination of disputes, they are not necessarily central to other forms of dispute settlement. The report of the Timor-Leste Australia Conciliation Commission addressed this issue in the following terms, and I quote, "There is a question regarding the extent to which a conciliation commission should engage with the parties concerning questions of international law. The function of a commission is to assist the parties to reach an amicable settlement, not to pronounce for its own sake on questions of international law. It follows for the commission that a conciliation commission need not, as a matter of course, engage with the parties on their legal positions, but may engage with these matters to the extent that so doing will likely facilitate the achievement of an amicable settlement. Away from arbitration and judicial settlement, therefore, non-liquet has much less, if any, relevance. Third, subject to the controlling caveat, this inquiry cannot give cover for the reduction of minimum standards. There is scope for fresh thinking about the proper role and content of the principle of exhaustion of local remedies and denial of justice. These principles stand at the intersection of the relationship between dispute settlement in the international sphere and the national sphere. Although there is a great deal of contemporary writing and arbitral analysis on these issues, the principles are deeply rooted in a bygone age. I don't rule out that a review may conclude that the role and content of these principles are where they should be and that no refresh is warranted, but I suspect that there will be more to say. Fourth, I would also like to see some further thinking on the issues of a system of reference and remand jurisdiction with a view to developing a more institutionally integrated system of international dispute settlement. With greater institutional integration, even if only loosely achieved, is likely to come greater substantive cohesion of law. Fifth, related to the issues of the relationship between international law and national law and between international courts and national courts, there would be merit in exploring further the so-called surlang principle expressed in the context of EU competence disputes. In essence, this postulates that as long as one system of law or court respects, in this case, fundamental rights, the other system of law or court will defer to the first. As cast, this is a protection lock, guaranteeing minimum treatment. But the concept could be readily developed further in the international space with a ratchet in both directions to foster more cohesive engagement between national and international courts. Sixth, associated with the proceeding, there may also be scope for further work to be done on agreed minimum standards of treatment, of conduct, of review, and more. If agreement can be reached on core elements, the debate will become more productive about the interpretation and application of such standards and less about their existence. Seventh, with a limited exception of Part 15 of UNCLOS and perhaps the WTO, there is a lack today in the international space of a clear articulation of the relationship and interaction between different modalities of dispute settlement. In the municipal sphere, much effort and analysis has been devoted to the interactive use of multiple methods of settlement to achieve the resolution of a given dispute. Some rules of procedure in the international sphere contemplate this possibility, but only rarely, and it is very seldom that such approaches are used. It is ripe for review. Eighth, at least two other big issues remain. The first is how better to address the reality of non-state active participation in a refreshed IDS system. Investor state dispute settlement and human rights proceedings accommodate this. Big issues remain, however, not simply in an institutional context with regard to ICJ or WTO proceedings, but also more widely with regard to long settled principles of diplomatic protection. This too might be usefully revisited. The second point is the thorny question of consent, notably as regards ICJ jurisdiction. While, however, this is a real issue with regards to the ICJ, it is less pressing in other contexts. Given the obstacles to the revision of the ICJ statute, this would not be at the top of my list of priorities. But the issue of jurisdiction ratione voluntatis would clearly be an important consideration in the context of any institutional innovation. I come to my concluding remarks. Although there was some discussion in the mid-1990s in the context of a steering committee set up by the Secretary General of the PCA of whether to revise the 1899 and 1907 conventions, nothing came of this. The stumbling block, it appears, was skepticism about the political will of states to accomplish such a task. I began this part of my discussion by saying that this was not a legislative moment. Now is not the time to think of revising the conventions. But taking a fresh look at them is not the sole preserve of states, and a fresh look does not mean revision. New instruments and new ideas can take many forms. These conventions on Pacific settlement are the standard bearers that still guide our way today, but they are from a different age. Why not look again at the template that they have bequeathed us to see whether some form of strategic refresh may usefully be captured in an elegant instrument of contemporary voice and vantage point? Here is a task for the Society, together with the PCA Secretariat and alongside the Society's national and regional counterparts. Why not take forward such a refresh? Why not explore whether a new, elegant text fit for the next 120 years can be crafted? Standard-setting endeavors, both binding and non-binding, are often taken forward through non-governmental endeavor. We should not wait for legislative moments. This is an initiative for our College of International Law today. Catherine, invisible friends and colleagues, it has been a pleasure to be virtually with you for the past hour or so. I hope I have given some food for thought. Charlie, I'm looking at you again. It's been a pleasure to speak in your honor. Thank you.
Daniel, thank you so much. You have indeed given us a lot of food for thought. We have a few minutes left, and because you've given us so much, I do want to try to take a few questions. Let me just start with the moderator's prerogative. I mean, you have thrown the gauntlet down. You have these 8 points that you've raised that go to the very basics of dispute settlement. Some I would think are vertically oriented in the sense of international vis-a-vis municipal law. Others are more horizontal on the international plane. You've talked about different modalities of dispute resolution. You've talked about how to think about the ratcheting between international courts and national courts. And you've made clear that you don't consider this a legislative agenda. And in fact, that gauntlet has been thrown down for societies, PCA Secretariat, alongside the national and regional counterparts. What, if any, role do you see in that process of rethinking, in that initiative of rethinking for states? I ask because as you've gone through the history, so much is fundamentally, this architecture is built on state buy-in, state consent, getting that political machine going so that you have the level of buy-in you need for this system to be effective. What in the refresh that you suggest, what role should states play, if any, in your view?
Thanks, Catherine. Always the most difficult question comes first. States, of course, have to be involved in some shape or form, and ultimately, if this is to affect states, there has to be buy-in in due course. But buy-in in due course is not necessarily determined by buy-in at the outset. And there may be very good reasons and proper reasons, as well as some that are less attractive, as to why states can't buy in at the moment. They may have their hands full with COVID. There may be domestic elections. There may be all sorts of other things that are going on. And I leave aside big sort of politics, which means that this is not the right moment to pursue things. But that doesn't mean that states cannot be around the table, even if only informally. We've seen lots of initiatives over the course of the last years and decades. Some more recently, we've seen, for example, Microsoft and others pushing initiatives for in the space of cyber, for attribution and accountability, and to establish organizations. We've seen a number of treaties subsequently adopted by states, but that have been drafted on the back of envelopes by NGOs sitting in small hotel rooms in Ottawa. And I speak with passion because at one point, that's where I was involved as a private practitioner advising. and then these things bubble up to states. There may be a role in quiet discussions with states unattributably around the table to clear the underbrush, things that will never fly and things that would be worth exploring. There may be a role to actually advance the thinking agenda so that one doesn't have to start with a huge mountain to climb, but can start halfway up the piece. So there are lots of roles. If we were to put this on the agenda of Marek String and others, Ian MacLeod in the UK, they would probably run a million miles away. Why give this to us now in the State Department and the FCO and sort of elsewhere? But this is important. If we don't turn the oil tanker when we see the bad weather coming, we won't have time to turn it in due course.
Thank you, Daniel. I know the participants have been invisible, but the chat room is full. Let me just take one from one of my favorite people, Harold Coe. Harold asks, has international arbitration become too judicialized? Does the Timor-Leste Australia compulsory conciliation suggest pursuing more quasi-diplomatic dispute settlement procedures?
Well, I'm delighted to hear that there's a question from Harold, because now I can speak to him directly. And I agree with Harold, and he and I were on opposite ends of that Timor-Australia conciliation sort of process. And while that had, for good and proper and very well understandable reasons, a challenging start, once everyone had got out of the starting blocks, with the help of a quite remarkable panel of conciliators chaired by Peter Taxo Jensen, now the Danish ambassador, I think, in Tokyo, but with others, including Rudiger Wolfram, who's been speaking before me in these past days. There was an enormous amount of cooperation and a drilling down into the detail. And in the end, the two parties sat down together and negotiated every word, dot and comma, of the treaty that was finally signed. There was buy-in in a process that lasted 18 months to 2 years. It was a remarkable achievement. Now, sometimes conciliation will work, not always. Sometimes you need litigation and the binary decision-making of an adjudicatory process to lance the boil. But sometimes conciliation would work. We don't give it a chance. I sort of feel as if I'm becoming the Beatles here. We need to give things a chance. So I agree with you, Harold.
Another one for you. Should judicial conservatism be a general principle? Could we keep different balances between judicial activism and conservatism in different areas of IDS?
I'd like to know who that's from, but maybe there's no name attached. One can write, presumably, on Twitter with some handle or other. But
that's right. Let me see if I can find a name. You answer. I'll try to find the name.
I think that there is a role for looking at all of these things. Sometimes I gave a lecture in the Society the last time that I spoke in a sort of formal capacity. I think was when I was still the legal advisor of the Foreign Office, and I spoke about the character of law. It's small c conservatism, but I also spoke about law being an instrument that is capable of breaking with the past in a decisive manner. So there is a role for law that crosses the boundaries and stretches the principle, but the law is generally small c conservative because it must be transparent and it must be predictable. So I would favor looking at how one can capture and articulate the idea of small c conservatism in the law, just as I would look at the role of being able to stretch the boundaries. The tension between judicial economy, saying only what you need to say, and judicial activism, saying too much, is a very real tension, as I know on both sides of the bar. That's something that we need to explore, with proper deliberation.
Thank you. And I think I can squeeze one last one. This is from Caroline Foster, who asks, will national courts' engagement in international law lead to their taking on part of the function of the executive in international legal relations?
Hi, Caroline. Good to see you. It's a long time since we've spoken. Maybe, I think one of the things that we've got to look at is we've actually got to look at the ability to exchange between national and international courts before we can script what that relationship is going to look like and what that role is going to look like. We have not frequently used, but certainly used on many occasions, a dialogue between national courts in different jurisdictions. And this is not just through mutual legal assistance, but where a national court through a judgment actually speaks to the judge sitting in a parallel case. This may happen in forum non-conveniens cases. It may happen in all sorts of circumstances. Why can't we have a dialogue between national judges and international judges? The international court, it's the apex court in our system, to quote an Indian expression for the way in which they refer to the Indian Supreme Court. The International Court of Justice is our apex court, but it is not the only court. And it is not the court that necessarily has all the wisdom on all issues. So there needs to be a dialogue between national courts and international courts, and that's what I would like to see.
Well, thank you very much. I've now taken us a little bit over, but it was worth it. I'll use the president's prerogative. Daniel, thank you so much. You have indeed thrown down the gauntlet, as I said, and let's see who and how and where we can pick it up. But thank you so much for being here.
You've got 2 years to pick up the gauntlet.
I noticed it was directed at me. I got that. Thank you, Daniel.
Thank you. Thank you very much, everyone.
Thank you, everyone.